consent is 16. So what it means is that in those circumstances, the 19-year-old boyfriend was liable for an offense, right? The second legal theme that we identified in that story was the fact that in all Caribbean countries, except for Guyana, adolescents or children. And the third legal theme from that story is the criminalization of abortion. In all, the abortion regime in all 19 countries fall under three categories. So at the extreme is the more liberal, which is Guyana, and Guyana stands alone, because in Guyana you can get an abortion on request until up about 12 weeks gestation. In the middle, you have 4 countries where abortion is criminalized, but there are exceptions are made for rape, incest, and the regular things that we know about. And then you have the majority in the third bucket, where abortion is criminalized. There's almost a total ban on abortion, except to save the mother's life. And so, in deciding where we wanted to start with or litigation approach, we decided to focus on that third legal theme, which is the criminalization of abortion, and we decided to start with those countries with the most restrictive laws. So that's what I mean by identifying a common story, a common legal theme that cut across all the jurisdictions, that cut across all the countries. The second point is about impact. And we had to decide what was the impact that we wanted to have. The abortion question is a question that affects 50% of the population in all of those 19 countries. And so in terms of impact, if we were to get the courts to decide that the abortion laws in those identified countries were unconstitutional, then we would be able to be impacting the lives of 50% of the population in all 19 countries. And the other thing that we focused on in terms of impact was which courts do we want to approach? So within the Caribbean countries, there are 2 final appellate courts. So there are some countries that go to the Caribbean Court of Justice, and there are other countries that retain the Privy Council. And as you know, the Privy Council is in the UK, and the same judges that sit on the UK Supreme Court are the same judges that sit on the Privy Council. Now, we know that the Caribbean Court of Justice is a more progressive court than the Privy Council in its judgment. And so we decided that in choosing the countries that we wanted to start off the litigation, we were going to choose a country that had the Caribbean Court of Justice as its final appellate court, and to choose another country that had the Privy Council as its final appellate court. Because a precedent set in either court would not necessarily be binding on the other countries, but it would be highly persuasive. And if, say, for example, we had gone with Dominica, if the CCJ was to decide a similar case from Barbados, then more than likely they would go with their judgment that they would have had in the Dominica case. And I'll just sum up finally by talking about building stakeholders and collaboration. The collaboration that we built focused on different areas. So there was a collaboration or the stakeholder that you needed to build in terms of the litigation itself. And so you needed to get lawyers. And because we started off without any money, there was no donor funding for the work that we were doing, we had to get pro bono lawyers. So we had to get the lawyers. We also had to get the litigators. Not the litigators, sorry. We had to get the litigants. So we had to get women who would be willing to come forward to be a part of a case, because as I mentioned before, abortion is highly stigmatized in the Caribbean. It is practiced widely, but it is highly stigmatized. And so we had to be able to find those litigants who would be willing to put their face and names to the case. And finally, in terms of stakeholder, we had to also work with the CSOs and also build relationships with people who were in government, because after you get the judgment, you want to be able to have that judgment implemented. So, thank you.
Thank you very much for sharing that perspective, and also the strategies that you had to engage in to make sure your case was in the appropriate court. Blessing Yamaropa, you are a strong litigator. What have been your experiences at the Zimbabwe Lawyers for Human Rights on similar cases and other issues that you may want to address to the room? Thank you.
Thank you. I think us at Zimbabwe Lawyers for Human Rights, we normally use litigation, both at domestic level, but we also use other mechanisms that are provided at regional and international level. And also maybe also speaking to continental litigation strategy. What I have seen is that we have similar challenges across Africa when it comes to the topic under discussion. We have seen that we have child pregnancies across, HIV infections across Africa, and so on. So for me, I think for us to be able to build a broader based litigation, what comes to mind is mechanisms like the African Commission on Human and People's Rights, where most African countries, they are party to these human rights protective mechanisms, the filing of communications. We know that, of course, communications are not binding, but they remain persuasive, and they can be used for further advocacy within countries to push for the necessary reforms. What also comes into mind is the utilization of the African Court on Human and People's Rights, which also issues binding judgments. And we understand that not many African countries have signed the protocol, and very few countries have even signed the optional protocol giving audience to its citizens and NGOs to this court, the African Court. But I think those countries within Africa that still have this privilege to file individual cases at the court, I think it's also a mechanism that is available to build continental litigation strategy, where organizations and many stakeholders can strategize in terms of bringing cases that can have a wider impact within Africa, and the judgment of the court can be quoted, I think, also in domestic courts to try to influence. But what also comes into my mind is also mechanisms like the African Committee of Experts on the Rights and Welfare of the Child. That is also a mechanism where even individual complaints can be filed, communications can be filed, and can be utilized to try to have broader impact judgments as part of our continental litigation strategy. But what we have also seen happening in most of these cases, given the limitations that are there with some of these regional mechanisms, I think what we have seen working is coordinated cases across African countries, which also resonates to what the Prof have also said, where NGOs, organizations, they agree to file cases within their domestic courts on a similar issue to try to push some changes that we want to see across some of these African countries. So a decision can be made maybe to have those cases